Well, this is part D of our final chapter, and we're discussing civil penalties, which is going to talk about fines. So you're going to need to know about fine amounts on the exam. So we're going to go through the fine amounts, and then we're going to summarize them so you won't have to worry about keeping them in order too much. You'll probably be able to remember them just with the summary that we provide. All right, a good rule of thumb to follow to begin with is that in general, the civil penalty typically assessed by the California Secretary of State is up to $1,500 per violation for notarial misconduct. Now, remember that these civil penalties can always be, of course, in addition to a denial of an application or suspension or revocation of a notary public commission. Okay, for your convenience, I'm going to cover a number of specific circumstances when a $1,500 penalty may apply. All right, here we go. The penalties up to $1,500 may apply in the following circumstances. The use of false or misleading advertising, wherein the notary public has represented that he or she has duties, rights, or privileges that he or she does not possess. Commission of any act involving dishonesty, fraud, or deceit with the intent to substantially benefit the notary public or another, or substantially injure another. Execution of any certificate as a notary public containing a statement known by the notary to be false. Violating the prohibition against a notary who holds himself or herself out as an immigration specialist or consultant, advertising that he or she is a notary public, or violating the restrictions on charging to assist the completion of immigration forms, and violating the restrictions on advertising notarial services in a language other than English, or literally translating the words notary public into Spanish. A separate provision of the law permits local and state prosecutors to recover up to $1,500 in a civil action from violators of the provisions relating to the unauthorized manufacture, duplication, or sale of the notary public seal and related offenses, including a failure to notify the California Secretary of State that a notary public seal is lost, stolen, destroyed, or damaged. What does this mean anyway? Remember that your notary seal must be manufactured by a company that's been approved by the Secretary of State to manufacture and sell notary seals. Now, the company would have had to submit an application to the Secretary of State, and the company must manufacture the notary seal in accordance with the strict guidelines that we've talked about earlier in the course. Now, you've already learned these guidelines, such as the maximum dimensions of the seal and the information that has to be on the seal and all of that. Additionally, if the notary loses his or her seal, or it's stolen, destroyed, damaged, or whatever, the notary is required to immediately notify the Secretary of State. Perhaps you'll remember that. If the notary fails to do that, the fine can be up to $1,500. If someone manufactures a notary seal without the authorization, the fine can be up to $1,500, and that's what this is talking about. Another category of the $1,500 fine amounts is willful failure to discharge fully and faithfully any of the duties or responsibilities required of a notary public. Now, we will discuss in just a few minutes that negligent failure is a $750 fine, but if the failure or the misconduct is not negligent but willful, it becomes a $1,500 fine. So we ought to really define willful. Willful misconduct is done with an intent to do the misconduct. For example, giving a notary seal to another person to use, or changing entries in the notary journal. So let's suppose you're going on vacation and you know that you're going to be having people coming in requesting notary services while you're gone, and you give your notary seal and a notary journal to a colleague and say, hey, go ahead and use that while I'm gone. It's no big deal. Well, obviously, that is willful misconduct. As opposed to negligent, maybe you have left your notary journal and notary seal in a desk drawer that's not locked. Other people in the office have access to it, and somebody gets access to that. Well, that is negligent failure because it was carelessness. It was doing something without an intent to do the misconduct. And carelessness, forgetfulness, those are more associated with negligent misconduct. But anytime you are engaging in misconduct with an intent to do the misconduct, it becomes willful. So willful misconduct, willful failure will become a $1,500 fine. Okay, let's talk about the fines and penalties in the amount of $750. Now, they're not nearly so many as in the $1,500, but if you can remember these, along with a few others that you'll discuss, you might not have to worry about memorizing all the $1,500 fines. I mean, we went through them and it's good that we did. And perhaps you'll keep a few of them in your head, like the $1,500 fine for translating Notary Public directly into Spanish, or the $1,500 fine for failing to post your advertisement if it's in another language in English and putting all of the required information on that post. You'll remember that was $1,500 fine, and some of the others that we talked about. So it's good that we at least talked about it. But we're moving to now $750 fines, and the point is that there's only like 4 of those, and so we want you to try to remember these, and then just a couple of others that we'll talk about, and then basically all the rest are $1,500. All right. Anyway, let's talk about the $750 penalties, but let's not forget that the notary may also have a denial of application or suspension or even revocation of their commission as a result of any violation, as always, and as well as being financially liable to the person or persons who were damaged by the notary's negligence or misconduct. There may be a penalty of up to $750 for charging more than the maximum fees for notarial services, failing to complete the acknowledgement at the time the notary public's signature and seal are affixed to the document, failing to administer the oath or affirmation, and negligently failing to discharge fully and faithfully any of the duties or responsibilities required of a notary public. Negligent violations would include, but they're not limited to, failing to maintain a notary public journal as required by law, taking improper identification, failing to provide information to the California Secretary of State within 30 days of a written request. Before I move on, I want to make sure that you understand what we have been discussing so far. First of all, we've talked about administrative penalties, specifically suspension, revocation, denial of application. That was the last video. This video, we're talking about civil penalties, which really discuss fines for those same offenses. We've talked about the $1,500 fines, and now we've just talked about the $750 fines. Now we're going to move on to other fine amounts. Several substantial civil penalties are possible if a notary public fails to either provide his or her notary public journal to a peace officer when requested to do so, or obtain a thumbprint in the notary public journal. Both of these can result in a fine of $2,500, of course, as well as a denial of application or revocation or suspension of the notary commission. The failure to provide the journal to a peace officer must be willful. In both cases, either the California Secretary of State or a public prosecutor may seek that civil monetary penalty. Now we move on to the really big fine of $10,000. But fortunately, there are only 2 types of cases where these fines might be levied against a notary. First of all, if a notary fails to obtain satisfactory evidence which is required to establish the identity of a credible witness, they can be fined $10,000. Remember that when using a credible witness, whether the notary personally knows that credible witness or not, the notary must use paper identification as we discussed in the course. Failure to do that can result in a fine of up to $10,000. Now, failure to obtain proper identification evidence for a document signer, you'll remember, falls under the category of failing to complete the Notary Act and subjects the notary to a fine of $750. But, for whatever reasons, in the case of a credible witness or witnesses, the fines escalate to $10,000. Now, you might well wonder why the disparity of the fine amounts, but it's important to note that for whatever the reason, there is a huge difference, and I want to make sure that you make a special note of that difference. The second offense that can result in a whopping $10,000 fine is if you falsify an acknowledgement. If the notary willfully states as true any material fact that the notary public knows is false in a certificate of acknowledgement, the California Secretary of State or public prosecutor may seek a civil penalty of up to $10,000. In other words, if you complete an acknowledgement for someone who's not physically present before you at the time of notarization, you've committed perjury. Remember that you sign the acknowledgement under penalty of perjury. It is not up to the notary to verify authorized capacity, but like with everything else, if the notary knows that the document signer is making a false claim, then the notary may not proceed with that notary act. All right, for your convenience, I've created a summary of fines, and you're going to be able to download this under the links section to the left. This section will also appear once again just at the end of this course, and you'll be reminded that you can download this. As you can see, most fines are $1,500, which of course represent the majority of violations. There are two $500 violations. Now, we've talked about those earlier in the course, but let me just remind you that willful failure to notify the Secretary of State of an address change or willful failure to notify the Secretary of State of a name change is subject to a $500 fine. There are $750 violations. We talked about those. You can go through those again if you like. Now there is one $1,000 fine, and the $1,000 fine is acting as an attorney by illegally giving legal advice or assistance, including selecting an acknowledgement or jurat for the signer. We talked about the two $10,000 violations. Feel free to print these out and be sure to take the sample exam over this video section if you want to make sure you have these fines memorized. Don't forget, however, the Secretary of State can always impose a commission suspension or revocation as a penalty for any of these violations.